Hello, everyone, and welcome to the section of Civil Rights and Social Justice's Demystifying the ABA Policymaking Process. I am your moderator, Matt Mecoli. I'm the co-chair of the section's Sexual Orientation and Gender Identity Committee, and I am happy to have you here with me today. I'm going to end this show briefly for a second. Don't worry, you will not have to see my ugly mug the entirety of this webinar, but have some written remarks I wanted to use to kick us off here. The Demystifying the ABA Policymaking Process is a webinar designed to teach you the ins and the outs of the resolution process. Let me first say that if this is your first time approaching policymaking at ABA or policymaking anywhere, I understand your apprehension and your uncertainty. A few months before the filming of this webinar, I embarked on my first journey to pass an ABA resolution before the House of Delegates. I knew nothing. I knew less than you know right now, but somehow with the help of some of the people on this panel and a great many others, myself and my team managed to make that resolution a reality. So this webinar is all about teaching you how to do the same. It's not going to be filled with kind of some of the empty tips you see in trainings or self-help books sometimes, like the best way to pass resolutions is to be good at passing resolutions, sort of tautologies or the believe in yourself stuff. This is all on the ground advice from people who have been where you are, who have passed resolutions, who have worked closely with the policymaking process. And passing an ABA resolution is not easy, but it is an incredible moment of satisfaction. And just as an aside, real quickly, during the 2017-18 bar year, the section's goal is to rapidly respond to government action that may impact civil rights and civil liberties by offering free webinars, commentary, podcasts, social media posts, and other information from subject matter experts. We encourage you to check them out on the section website, our Facebook page, and our Twitter for more news and information, as well as replays of our great programming. If you like our work, we invite you to become a member of the section and collaborate with us on projects you want to develop and offer to our members and to the general public. So with that, to kick things off, I think I'm going to have each of our panelists introduce themselves. Quick. Estelle, would you mind getting us started?
Of course. My name is Estelle Rogers. I am one of the two section delegates for the section of Civil Rights and Social Justice. I've actually been in the House of Delegates for over 20 years, which is hard for me to believe, but I have learned the in and outs of resolution making and advocating for resolutions, and I'm happy to share that with all of you.
Great, thank you, Estelle. And Kristi, would you jump in next?
Sure, I'm Kristi Gaines. I'm a senior legislative counsel in the Governmental Affairs Office of the ABA here in DC. I've been with the ABA 21 years now, and in addition to my sort of day-to-day advocacy for the ABA, I'm also our office's liaison to the Rules and Calendar Committee of the House of Delegates, which is the entity that reviews all submitted proposed resolutions.
Paul, would you mind jumping in?
Sure, this is Paul Wolfson. I am on the Section Council. I'm also the chair of the Section's Committee on Amicus Curiae Briefs, and I also serve on the ABA's Standing Committee on Amicus Curiae Briefs.
Great. So as you can see, everyone on this panel is significantly more experienced than I am, and you should definitely listen to them and not I. We're going to kick things off and get into this. I apologize if my fire alarm goes off at any point. It's been doing that throughout the day. Something going on in my building. So Estelle, if you could walk us a little bit through what someone who doesn't even have a resolution or report in front of them yet, who just has the idea, what they need to do to make that resolution and report a reality, and to get that to the point where they're even submitting it to their section or to the House of Delegates.
Okay, thanks, Matt. As I mentioned, I've been in the House of Delegates for a long time, and I've had a part in resolutions at really every stage of the process over the years. This is sort of like how a bill becomes a law in your fourth grade civics curriculum. The ABA has certain ways of doing things, and although they seem obscure. Once you get the hang of it, it's really not so hard. First, I want to mention that there are 2 publications by the ABA that are available to you, and I think the section actually gives them out routinely, and they're a great start. So before you get into it very deeply, they're a great resource to read. First off is something called Policy Made Easy, and the second one is called Drafting Guide and Style Manual for House of Delegates Resolutions with Reports. So that's just by way of background, and I think what I would like to do and what all of us are going to do is give you some fill-in between the lines of those publications to be much more practical and down to earth and concrete. So there are 2 examples I can give you of recent policies I've been involved in addition actually to the one Matt wrote, which I was less involved in because they did such a good job they didn't really need me. The 2 are policy, and these are both very timely, so they're issues that you can relate to right away. The first one is gun violence restraining orders, which you've probably heard quite a bit about lately, and that is the mechanism by which a court can decide that someone is in imminent danger to himself or others and therefore should have guns taken away from him. And this urges states and localities to pass this procedure, and some have, and I don't know how many have since the resolution was made final, which would have been last summer, but it's a very timely issue, as you may have heard. The second one is a policy on sexual harassment, which the House of Delegates just passed in February, and it calls upon law firms to put policies in place, including the following basic principles, and they have to do with process, with notice, with involvement at the highest levels, with keeping records, all the kinds of things we like in lawyer due process resolutions. But those are just examples, but the basic gist of resolutions is that you are calling upon somebody to do something. And it can be, as I mentioned, a governmental entity, and it can be the legal profession. There are other examples, I'm sure, but that's the usual pattern. And the writing of a policy, I think, should begin with subject matter experts, like committee chairs, for example, who recognize a need and want the ABA to be able to officially weigh in on a legal issue. So the gun violence restraining order and the sexual harassment policies are great examples of this. There are many others. The one actually that Matt was involved in had to do with an interpretation of Title IX. I'm wrong, Matt. It's Title VII, isn't it? You're on mute.
Title VII.
Anyway.
The Title IXs are the one that we're working on right now.
Okay, but it was an interpretation that sexual orientation and gender identity be included as a category that should be immune from discrimination. That's the gist of it. And that's another one that sort of asks for an interpretation. There's a fourth one that I should also mention that asks the Congress to override a court opinion or a number of court opinions that are inconsistent with each other. So that just gives you a survey, essentially, of the kinds of things that can be ABA policy. But as I say, I think the recognition by subject matter experts that we need a policy on something is a place to start. And we rely on committee chairs and other members of the council, committee members and other members of the CRSJ council. We also can be approached by another section in the ABA saying we would like you to be involved in this. It is a criminal justice issue, for example, but it's also a civil rights issue. It would be a stronger resolution if we worked on this together. So all of those things can happen. I think that one of the first steps should be looking up prior ABA policy to make sure this hasn't already been done. And even if it has already been done, there may be an evolution in the issue that makes a new policy necessary. It could just be a nuance. It could be a major change in legislative proposals, but an update is needed. So those are the circumstances in which ABA policy should be developed. In addition, prior ABA policy is something good to put in the report that accompanies the resolution. Number one, they ask for that. But number two, it also gives the House of Delegates some sense that this is an evolution and not a revolution in ABA policymaking, that we have, trod this ground before. And I think that can be a convincing point. As I mentioned, making alliances with other entities in the ABA can be very important, and getting them involved from the get-go is often a great way to ensure that the resolution will be passed. And learning how to sort of deal and compromise is an important ingredient. Obviously, you don't want to compromise so much that the original intent is lost, but there may be some easy cosmetic changes, for example, that mean a lot to another section and don't really do violence to the point of the resolution. A couple of other little things before I turn the program over. It is a great idea to run the language by the Governmental Affairs Office to make sure that it would enable the ABA to lobby on what you want this to do. If there is a resolution, a bill pending in Congress that you're sort of directing this at, and the language doesn't give the GAO enough room to maneuver, they will say this isn't going to do it. Also, the Amicus Committee and our Amicus Committee, meaning Paul as the chair, would be helpful in predicting whether this is going to be specific enough to get an amicus brief in a case that we want an amicus brief filed in. And finally, the House of Delegates Drafting Committee, which can help with the technicalities of the drafting process. My rule of thumb, and I'll conclude with this, is that you want a resolution to be specific enough to do the job you want it to do, but broad enough to give these pieces of the ABA enough flexibility to be able to respond to changes in the legislative or litigation process. And I think that's a good place to. That's it for me.
Absolutely, and thank you, Estelle. And I definitely echo everything you said. I'm going to pull up on screen here for a second. So if anyone is listening right now but not watching, look at your screens just for a second. I'm actually going to pull up some of the things that Estelle just talked about. If you look right here, this Excel document that you should see on your screen with a whole listing of all the policies, these are all the policies related to sexual orientation and gender identity that the ABA has on record. You can go through your staff. We have a wonderful staff at CRSJ. They were able to provide this for us. Other sections and entities have equally wonderful staffs, almost equally wonderful staffs. And none quite rival ours, but they can give you this document or give you a version of this document. And this is a great place to start. Like Estelle said, if you're looking for, has this been done before? Has it been fully covered? So maybe someone talked about bullying, but you want to expand upon that. You can look here or look to a document like this to help you figure that out. And then I'll pull up the resolution language real briefly here for you as well. I think it might be helpful to just see what a resolution looks like. And this is where sometimes drafting, as you said, can really come in. I don't know if this is the final version or not the final version, or there were quite a few revisions along the way. So let me pull up. This is an example. This is an example of the resolution we just passed, 116A. This is sort of what it would look like. A lot of the formatting you can find. The ABA has something called the ABA Drafting Guide. Again, your section staff should be able to provide that for you. And this is sort of the format of what the resolution part will look like. Sometimes they're longer than this, sometimes they're not. We divided it up into two parts. Notice we talk a little bit here about interpretation of the law, and then we talk a little bit about something that's going on with the Attorney General's office and with the DOJ. So as Estelle said, those are some general areas, and then you launch into the report. You talk a little about previous policy, and then you get into your actual nitty-gritty. And the drafting committee can definitely help with all of that. And as as Estelle mentioned, one of the things that you occasionally want to do is you want to reach out to people like Paul and Kristi during this process, because they're the people that are going to be actively involved should you manage to get your resolution passed, which I'm sure you will. They're the people that are going to be involved in actually implementing it or bringing that resolution to life in the real world after it gets passed. So, Paul, could you talk a little bit about what you look for maybe in a resolution or your experience working with resolutions before?
Sure, thanks. This is Paul Wolfson speaking. As Matt said, I'm the chair of the section's Amicus Curiae committee, and I've been involved in the preparation and the approval of many, many amicus briefs filed on the ABA in the last few years. And the good news is the ABA is actually, pretty well disposed towards filing briefs in subject matters that are of interest to this particular section. So we filed briefs in same-sex marriage case and on the Voting Rights Act and things like that. But having said all that, there are a lot of hurdles to go through. I'll just speak before I sort of speak at greater length. I'll talk just to the specific issue that Matt mentioned, which is what is useful in a policy to sort of to get the amicus brief process done. Because one of the requirements for the ABA to file an amicus brief is that there does have to be policy on point. And, it can be debatable whether a policy is sort of specific enough to cover a particular amicus brief, but the policy should be, if you are drafting policy with a view towards filing an amicus brief, you should think about drafting it in a way so that it will be considered to be sufficiently specific to cover an amicus brief in an appellate court. The other thing I would say is pay very careful attention to the recommendation part, not just the resolution, because the recommendation part where you set forth the reasons why the ABA should adopt the policy and provide the legal argumentation for the policy, those can be very helpful to the Standing Committee on Amicus Briefs and then eventually to the drafter of amicus briefs, because although those technically aren't binding, they serve as a kind of legislative history of policy, and they help the drafters and the amicus committee understand, in a sense, what is driving the ABA to adopt a policy, and they help smooth the way to getting an amicus brief approved, I think, if the amicus brief can then map onto the rationales that are set forth in the recommendation.
Absolutely. And if you turn your attention to your screens for a second, I brought the resolution back on. As you can see, we have like 8 sentences that are actually the resolution, and the report goes on for about 8 pages of just trying to make sure that we get as much in as condensed a space as possible to fully explain why it is we're doing what we're doing and the legal ramifications and sort of position behind it. Sorry, Paul. Didn't mean to interrupt.
Sure. Shall I continue with just discussing the amicus brief approval process?
Yeah, absolutely.
Sure. Thanks. So let me say a few words about this. The first thing, before I go into any of the details, the first thing I would say is, early preparation is essential because the approval process takes a fair amount of time, several weeks, sometimes, a month and more. And when you are dealing with a case that sort of has just been granted on the Supreme Court, that can often be a little late to start the process going. So scout out the issues early on which you want to file an amicus brief. Talk to the people who, the ABA is often approached by people who are hoping to get amicus briefs approved. Have those conversations early. Line up your lawyers who are going to be drafting it, all of that. So early preparation is essential. the ABA, as I mentioned before, it's essential that there be policy on point. If you are trying to get an amicus brief approved, and I'll talk a little bit more about the process for that, also give thought to what is the compelling reason for why the ABA should file in the brief. That is, the ABA does not like to file briefs that simply, make the same arguments on the merits that a party is going to make. It's important that there be a distinct perspective that the ABA can bring to it, and that can vary depending on the kind of case, but it's important to think about that issue. Start early, as I said, get a law firm with Supreme Court or other appellate court drafting experience lined up to do the case pro bono. There are many law firms that are eager to do so, but it does take a while for that, them to get that process approved internally. And it is important to get a firm that has experience in doing Supreme Court and appellate briefing. I think that is more important than getting a firm with particular experience in the particular subject area, because if you get one, it'll get the approval process to run more smoothly. Generally speaking, the ABA files briefs on the merits in the U.S. Supreme Court, and that is the focus of its amicus brief efforts. It is much less common, although not unheard of, for the ABA to file a brief at the cert stage in the Supreme Court, and for the ABA to file briefs in federal appellate courts, sometimes depending on the nature of the issue. It may file a brief in the Supreme Court of a state. All of those, I think, require some special justification for why the ABA would do that. The ABA almost never, to my knowledge, files briefs in amicus briefs in trial courts. So the focus should be on the merits in the Supreme Court of the United States, and the others are more difficult to do. Roughly speaking, the approval process goes something like this. First, you need to get the section to be the sponsor of the brief. So you should, if you are interested in having the ABA file a brief, you should contact section leadership, including Tanya or Paula or myself, to get that process going and to vet the possibility of filing an amicus brief. We have a 5-person amicus committee that meets as needed to discuss proposals for filing an amicus briefs. Then you need to fill out an application form. There is an application form that the ABA has in which various fields have to be filled out, including the history of the case, what the arguments on the merits would be, and in particular, what is the sort of special justification for the ABA as opposed to some other entity to file an amicus brief in that case. So a lot of attention has to be paid to filling out that form, and that usually will be done in consultation with section leadership, including the 5-person amicus committee that I mentioned. That form will then be submitted to the ABA's Standing Committee on Amicus Curiae Briefs, what we call the Big Amicus Committee, which is actually not that big. It's 7 or 8 people. And that will then be reviewed. The application form will then be reviewed by the Amicus Committee, and they will decide as a preliminary matter whether to go forward with the amicus brief, depending on, of course, on whether the brief otherwise comes together, or whether, for whatever reason, the proposal to file the brief just doesn't meet the needs of the ABA or the requirements that the ABA has for filing an amicus brief. Once that application form is approved, the law firm will then proceed to draft the brief. The ABA goes through a pretty rigorous process of editing amicus briefs. The amicus committee usually requires at least two edits or 2 rounds of the brief to review. Sometimes it's preferable to do an outline first and then a full brief and then another revision to the brief. There have been times when they've required a 3rd or an even 4th round when it's a particularly difficult brief or when they're, where the amicus committee has particular points of view that they need to get across. The brief, that draft of the brief can be vetted with the section leadership as well, and that can be very useful. The amicus committee will appoint a contact member who will be responsible for giving you comments on the brief and helping you sort of get through the process. Once the big amicus committee approves the brief, it then actually has to be formally approved for filing by the executive committee of the Board of Governors, so that takes another little extra step. All of these take a fair amount of time. The big amicus committee meets every Tuesday, so you have to get them the draft of the brief by a Friday, and so forth. So all of this sounds pretty bureaucratic, maybe even it is, but what it is designed to do is to make sure that all the reviewers have enough time to be sure that the content of the brief meets with the amicus committee's sort of concept of what the brief should say and how it meets ABA policy and whether it's just sort of well written and forceful, and to make sure that comments are internalized by the drafters with enough time. So again, early preparation is essential. Leave as much time in the process as you possibly can. And if you do that, it actually will come out well. The ABA has, in my view, filed some absolutely fantastic briefs in the last few years. I think they've been very forceful. So although the process is a little bit arduous, I think the end product can be well worth it. Thanks.
Matt,
yeah, absolutely.
Can I jump in for a minute? Can you hear me?
Sure. Yeah, absolutely.
There were a couple of things I wanted to add to Paul's excellent rendition of how this all works. One is that's worth highlighting that the ABA doesn't finally approve an amicus brief until it's written. So in other words, the preliminary going forward is we think the subject matter is something the ABA can contribute to and we have policy on. That's one stage. And then you submit a written brief, and that's the other stage. So you're only halfway there when they agree that an amicus should theoretically be filed. That's number one. And number two is that the ABA does not join others' amicus briefs. So in other words, if you have, as you often do, 14 attorneys general of the states file an amicus brief on an issue before the Supreme Court, or 12 civil rights organizations, et cetera, the ABA never gloms on to anybody else's brief. So that's important to know from the get-go. The ABA has to do its own, and it has to be developed from a particular point of view that the committee thinks is unique to the ABA. That's all.
Absolutely. Thank you, Estelle. And yeah, that's an excellent point. I mean, the first step in the amicus process, and the step that you may be at if you're watching this, is definitely to get the policy on the books. And then to go through this process of making sure that you have everything in order, and that you follow what Paul said very concisely and very well about the process of getting an amicus actually together. And what I would say is, both Estelle and Paul have made offers to, reach out to us and ask. Those aren't fake offers. You should absolutely feel free to reach out and ask to the senior individuals in your section or in CRSJ specifically their advice and their expertise. Paul was very helpful. Estelle was very helpful during this process. So that is not at all sort of an empty offer. And the other side where policymaking can come in outside of the litigation stage is through the Government Affairs Office, which is the lobbying wing of the American Bar Association. We're lucky enough to have Senior Legislative Counsel Kristi Gaines with us here today. Kristi, would you mind explaining maybe on your end what policy does or does not do, what you look for, what's helpful for you to have in a policy?
Sure. Thanks, Matt. So I'll just say for everyone who may not know, the ABA does have a Governmental Affairs Office here in DC. We have about 9 legislative counsel who are all assigned different issue areas. So often the legislative councils are good resources, as Estelle said earlier, maybe to start with. We have a list on our website of each person, their contact information, as well as the issues listed that they deal with underneath. So you can go and see if which lobbyist deals with the issue that you're interested in, and give them a call. You can find out, what the ABA already has been doing, what we may need to be doing, and other things. So I would urge you to use that as a resource. Obviously, we here in GAO deal more on the policy implementation end versus the policy development, but really they're so mutually interdependent, because we cannot, as Paul noted in the case of Amicus briefs, in terms of any advocacy, the ABA cannot speak on an issue without a policy resolution that justifies our position. So the sections, activities related to policy development are really what enable us to engage in public policy debates. So I would just say, think about that as you're going along the process. I'd also like to reiterate Estelle's point of the first step that you might think about is, does the ABA already have some existing policy? Because if we do, we may be able to engage immediately on an issue. And if we do have some, but there may be gaps, you can identify those gaps. There are a number of resources that you can use in addition to the list Matt mentioned and section staff. We here at GAO on our website keep a PDF document that lists a summary of every single current active ABA policy. Also on the House of Delegates website, you can find the ABA Policy and Procedures Manual, which is otherwise known as the Green Book because of the color of its cover. In Chapter 13 of that manual, it starts a lengthy list, again, of all 1,100 plus summaries of ABA's active policies. In addition, the ABA on its website also has an online policy library. If you go to the website and at the top you'll see an advocacy button, and if you hit that you'll see a link to the online policy library. You can search that online policy library by keywords, names of organizations, and other things that may allow you to find some of our existing policies. And also, again, I encourage you to reach out to the lobbyists that might cover the issue areas that you're interested in, and we can help you as well figure out if there are areas, where we need some additional policy. The other thing I might note here is if you do that investigation and find there is some existing policy, don't think that your role has ended, because while existing policy is necessary for our activities, we also very much rely on the efforts and expertise of ABA members to help us in the implementation process of those policies. So very rarely when we're engaged in advocacy do we just send out the policy resolution to people. So we, write advocacy letters, statements, prepare one-pagers, sometimes infographics to get the message across. So, if you or your committee or other entity is really interested in an issue and you see a policy that is already there and it's fairly recent and you think, well, there's nothing for us to do, please don't think that. Let us know that you're interested in doing something on that. We may have many, many things that we could ask that you would work with Government Affairs on in terms of developing additional resources, more recent information if the policy is a little bit older. So I would just encourage you while taking that first step to find if there's existing policy, don't be discouraged if you find it. There may be other steps that you can help with in terms of our implementation of that policy. I will say on the sort of specifics of how we use and look at policy, the ABA, like many other organizations, engages in advocacy on a number of levels. As I noted, we send letters, we submit statements, or have people appear before congressional committees. We have an annual advocacy day. So all of that is based on, our positions that are produced through our policy development process. So thinking about that, I would also reiterate Estelle's comments on thinking about the specific language that you use. And this is always a difficult line to walk because we want it to be specific enough that we can sort of get a little bit into the weeds on some issues, but also general enough that we're not wedded to only one specific idea or concept and then can't discuss or debate the merits of maybe other specific provisions of legislation or ideas. And I know it's a little bit difficult. There's no bright line to help everyone figure that out. But again, talking to your section leadership, talking to us here in GAO, we can sort of help you figure out what kind of language would allow us to engage in what kind of activities. I will also echo Paul's comments on the importance of the report. ABA policies, only the language that's in the resolution is the official ABA policy, and that's what we work off of. But the report is very important in explaining the issue, identifying the problems that led to our making these recommendations, providing very good background, statistics, and other information that really explain, a little bit more about what our recommendations are, why we're recommending them, and why the ABA cares about these issues. We here in GAO use those reports every single day. We draw information from the reports to be used in our advocacy efforts. So they're very, very important. The only thing I would note is you do need to be careful that the report itself reflects the recommendations in the resolution. If the report contains what could be considered recommendations beyond the text of the resolution, that will be flagged and will create a problem. So that's just something to keep in mind on that front. The other thing I'll say about both resolution language and report language is here in Washington, obviously, at various times, different political parties and individual office holders change frequently, and we need to remember that we're not just looking at advocacy activities in today's environment, but potentially 2, 5, 10 years down the line. So one of the things that we look very careful for is to make sure that the report is done in a tone that is not specifically political or partisan one way or the other, that it is not overtly criticizing any or harshly criticizing any particular office holder. Just be aware that we will need to use this information. It becomes public information, and potentially the kind of language that we use in these documents can impact, the reputation of the ABA and our ability to, get results through our advocacy efforts. So that would be one thing I would also encourage you just to think about is to ensure that you talk in a measured way. That doesn't mean it can't be, energetic and passionate and strongly supporting your issue, but talking in a way that's respectful to all parties involved and ensures that it doesn't inadvertently undermine us with parties that we may need to try to persuade on any particular issue. So I will leave it at that and ask if anyone has particular questions for me or wants to add to what I delivered.
I'm definitely going to echo what you just said about making sure that you keep the tone appropriate. I mean, in the resolution we just passed, we specifically mentioned the Office of the Attorney General and Department of Justice, but we made sure we did so in a way that was neutral, not personal, and was pointing out that we had a legal disagreement, not that we had a personal or political disagreement. And there's definitely a way to do that. Even when you strongly or vehemently disagree, you can keep it on a legal level and not make life more difficult for the folks at GAO, because they definitely have their work cut out for them. So what I'm going to do is I'm going to take this time to send out a few specific questions to different members of our panel, and also just to make a couple comments myself. I think what you've seen so far is definitely very clearly why it's important to have resolutions or to make policy in the American Bar Association. There are definitely organizations, I'm sure you can think of some, where resolutions are sort of empty gestures. or policy doesn't really matter. I worked at city council in a city that shall go unnamed, and there were plenty of resolutions that were sort of empty gestures. That's not the case in the American Bar Association. Most of the resolutions that go through the House are there so they can create policy so people like Paul and Kristi can do really, really good work with that. It is the first step in any of your advocacy efforts is to get the ABA policy on the book in the first place. And then you can go from there. So it's definitely important to look and see if there's policy already existing. And I think that brings me to the conversation about how you actually go about this. Having just done this, I could tell you, you don't go about this on your own. You definitely don't go about this on your own. You go about this as part of a team. I had a group of individuals, some people were working on drafting, some people were working on contacting other people. You should definitely, while doing your drafting, reach out to section staff, to GAO, to your Amicus committee, to the delegates in your section. You should reach out to the House of Delegates has a wonderful drafting committee. At the time of filming, I believe the chair was Christina Plum. She is amazing. She's very helpful. They're willing to read your resolution, send you back results. You should feel free to reach out to experts in your field. A lot of times people that are experts in their field do it because they're passionate about it, which means they're probably willing to give you a little bit of time if they're able to give you a little bit of advice or at least steer you in the right direction. And as you can see, I'm going to share my screen again briefly for a second. There are a lot of edits and a lot of versions of this resolution before we got to anything that looked anywhere near a final resolution. So talking to those people along the way is the way that you sort of go about that process. I wanted to pull up briefly the Green Book here that Kristi mentioned. This is the Green Book. It is a long 435-page beast of a book. The section that you're looking for, among others, is right here. It's chapter 13. It goes through, if you need to look up a policy real quickly, and you don't have one of those handy dandy charts, this is a great place. This is something that I should have thought of as well. Right here, the place to go. Now I'd like to ask a couple specific questions to our panelists while we have them here. Estelle, would you mind talking briefly about the difference between a sponsor and a supporter, and the sort of the different process there? Because this is something that I learned in the process of doing this.
Yes. It used to be that that anybody could call themselves co-sponsors, and it became a bit of a badge of honor when you had 13 co-sponsors, 12 sections and a committee. That is not allowed anymore. A co-sponsor is defined as an entity that has been in from the beginning in the thinking through, in the drafting, in the negotiating of a resolution and report. So as I said earlier, to use an example, that the section often collaborates with the criminal justice section, and the best way to do that is to say to them in the beginning, we have a mutual interest in this, let's work on developing something, and then they can be listed as a co-sponsor. And that can be very persuasive to have different angles of the issue represented in the co-sponsors. A supporter is an organization or an entity of the ABA that identifies itself as being supportive, so that generally it's the result of a vote in their council meeting. So timing of that kind of thing can also be important, by the way, to give different sections a chance to meet to decide whether, what they feel about this resolution. But that can be any number of entities, and it may be essentially ignored when you get to the House of Delegates, or the presenter of the resolution might get up and say, we have the support of, the following 12 sections. And that can be very persuasive for people who are nervous about the issue.
Absolutely. Thank you. And then can you talk a little bit also about what it's like during the actual House of Delegates meeting? I didn't get a chance to go last time, but I will definitely be there for this upcoming one. And I'm interested to hear what it looks like once your policy is approved and once you're on the ground at one of the ABA meetings.
Yeah, I'm glad you asked that. One of the introductory things I should have mentioned was what the House of Delegates is and how it's organized. The House of Delegates is representatives from all of the sections of the ABA, the state bars, the quote-unquote affiliated organizations, which are, for example, the National Bar Association and other minority bars, a number of special interest bars like the I can't remember what it's called, but people who do intellectual property or communications might have their own bar. So they have to be of a certain number, and they have to apply to be affiliated organizations. That's all a long way of saying there are others that you might not think of right offhand that have representation in the House of Delegates. There are 500 and some, I think, members of the House of Delegates. It's huge. It's a lot like the House of Representatives of the United States. And the layout of the House of Delegates meeting it's always in a hotel ballroom or 3 or 4 connecting hotel ballrooms or a convention center, and it is organized by state. So in other words, I'm from California, and there is a very big delegation from California, and some of the people are section people like me who happen to be from California. Some of the people are state bar people. Some of the people are affiliated organization people. There's also county bars. So it can be any one of a number of origins of these people, but they sit together in a state delegation. And the way things work is there is a presenter of a resolution. Each one goes in order, roughly speaking, and the presenter gets up and has, I think it's either 5 or 10 minutes, depending on the controversiality, if that's a word, of the resolution. If it's got no opposition, they have rules of limited debate, which I think is 5 minutes. And if there is opposition, they have 10 minutes to introduce the subject matter. And then generally speaking, it goes back and forth between proponents and opponents. And in order to speak, you put in a request to speak, which we call a salmon slip because of the color roughly that it is. Some people think it's pink, but in any event, they call it a salmon slip. So you have to get permission to speak. It's routine, but you do have to file this piece of paper, and sometimes this can happen days in advance, and sometimes it happens while the debate is going on. You say, oh my, I've really got to oppose that, and you take this piece of paper up to the front of the room to a committee called Rules and Calendar, which also, by the way, can be very important in the process of drafting and debating the wording of a resolution and report. So that's another one to flag, the Rules and Calendar Committee. That answer the question enough?
Yeah, absolutely. Thank you. And if you're a crazy policy nerd like me, you'll be sitting on the ABA Twitter feed, refreshing every couple seconds until you see that your resolution passes or doesn't, which is definitely what I was doing. Real quick, I have a brief question for both Kristi and Paul. If you wouldn't mind, could you give an example, somewhat similar to what Estelle did, of a recent policy you worked on that you think was really well done, that might be used as an example for someone that's just entering the policymaking process and looking to maybe find something that's the epitome of good policymaking or good resolution?
Kristi, you want to go first?
Sure, I'm happy to. So I would say, I could give lots of examples on both sides of that issue, but I would say one of the recent issues that where there was a very collaborative process was working with, there was a special working group set up on unaccompanied immigrant minors or children, and the Commission on Immigration, who looking at something that was going on in Congress, which was to strip away the protections for unaccompanied immigrant children that are currently provided in the Trafficking Victims Protection Act, very quickly sort of looked at, worked with me to look at various aspects of the proposed bill where we didn't have really good and specific clear policy. They then, went through and worked collaboratively together as the two entities and sort of laid out resolution language that hit each of the sort of major issues in the provision of the legislation, which would allow us to clearly oppose those provisions. And I can get the sort of, meeting and resolution number for people who would like to look at it. But it was, again, just a good example of a collaborative process. And it was, the text was shared back and forth between the two entities. And I think also CRSJ was also involved with that. So I think that was just a good example of the collaborative process and some very clear and current recommendations that came out of it.
So this is Paul. I definitely in the area, there have been a lot of policies recently in the area of sexual orientation and gender identity, which the Commission on sexual orientation, gender identity, and also with the CRSJ committee, have been very proactive in following the case law and sort of anticipating the issues that were going to be litigated in the courts and in developing policies so that when the case got up to the Supreme Court, we would be ready to file a brief. And I think those have been kind of excellent jobs because they've been sort of very practical. The ones that sometimes can be a little more difficult are where a policy was sort of enacted not with a specific case in mind, but sort of as generally supporting a particular point of view. And sometimes when a case ultimately gets up to the Supreme Court, those policies can be, 6, 7, or 8 years old. And it can be a little difficult to sort of, or a little bit challenging sometimes to make the case that they're specific enough to support taking a position in litigation, especially since the issues that come up in litigation, are sometimes a little bit unpredictable. So I think it is definitely worth doing what Kristi suggested, which is if you see an issue come up, go back and look at the inventory of policies and see whether it's appropriate to kind of brush it up so that you have a policy that's specific enough to support an amicus brief.
And Matt, if I could just jump back in for a second. So the policy that I was referring to was at the 2017 mid-year meeting. It was Resolution 301, and there was a number of groups involved with it. But looking at the Daily Journal from that meeting, I also wanted to just say a quick word about timing. As I think Estelle noted, and Paul certainly for amicus briefs, lead time is often key just because of the ABA's rules. So, for example, for the 2018 annual meeting, which will occur the first week of August this summer, the submission date for resolutions is May 8th. So obviously that's several months before the actual meeting. So generally you have to think as much in advance as you can. However, again, don't be discouraged if for some reason you can't make that deadline. If there is a issue that emerges that is current and is, there are exigent circumstances, the section can submit late reports. State and local bars and affiliated organizations can actually submit any report. It's not even considered late, right up until the day before the House of Delegates starts. Obviously, that's not ideal because you want to engage in a collaborative process, making sure that others don't have objections or issues with your position, but it can be done. And one example for that, for example, was at the 2017 mid-year meeting. Obviously, at the end of January of that year, the current administration had issued some executive orders that we refer to as the travel ban, which excluded individuals from certain countries from entering the United States on any basis. And there were a couple of entities, including the Connecticut Bar for one resolution, and then the Section of International Law in conjunction with CRSJ and several other ABA entities that moved really quickly, and I'm talking about within a week, to get 2 resolutions drafted, checked and vetted with each other, and submitted to the Rules and Calendar Committee the day before the meeting happened, because that was an issue that was so important for the ABA to speak out on. They utilize that procedures, which do allow you to do that. So I just, again, wanted to state, while you do need to be mindful that generally you need a lead time, if there is an exigent or urgent circumstance, there are ways that we can get a resolution to the House very quickly.
Awesome. Thank you. Timing's a really good thing. Absolutely. And being aware of those deadlines and then figuring out a way to either make them work or find a way to make them get around them, which is all in good lawyering. I just have one final question for everybody here. If you could share your first memory or your first time working with the American Bar Association, for all of those new people who may be very new to the policymaking process and to the ABA, might be helpful to hear all sort of first ABA experiences.
Well, this is Estelle, and I have a doozy. I got involved in the ABA in the late 80s. And it was a time when there was a lot of litigation, and I guess some legislation as well, about the abortion issue. And it was leading up to the Webster case in the Supreme Court and several others over several years. Some of us thought that the ABA should have a policy on the right to privacy as it relates to reproductive rights. And that was a resolution that we brought to the ABA in 1990, and it then was reversed by a subsequent House of Delegates in 6 months later, and then brought back in 1992 and passed and has not been revisited. It is essentially the ABA saying that the parameters of the decision in Roe v. Wade were a reasonable expression of the constitutional right to privacy and should be retained. The one thing I'd add to that is that there was a very aggressive, prior to this, there was an aggressive attempt to get an amicus brief from the ABA on the Webster case, which I believe was in 1988 or 89, and was turned down because there was no ABA policy. And that's what led to this push to get an ABA policy on that issue. That's it.
That is certainly a trial by fire.
Exactly.
So this is Paul. I had a little bit of a different, sort of, in some sense, kind of the opposite experience, which is I got roped into drafting an amicus brief for the ABA during the addressing the Bush administration's indefinite detention of people in Guantanamo and use of military commissions to try them instead of Article 3 courts, or even something that would be like a court martial. Now, there was no question the ABA was going to be involved in that. The ABA sort of stepped in very vigorously. Actually, let me say that. There was a period of caution in which the ABA was a little bit uncertain about what to say about that, because they certainly did not want to sort of dispute the fact that national security was essential in a post 9/11 period. And they did not sort of take the view that the president could never do anything short of having a trial in Article 3 court. So there was a little bit of a period in which the ABA, I think, was sort of searching for its exact voice on what it wanted to do. And there were, forces within the ABA that wanted the ABA to take a more kind of vigorous and oppositional stance. As the issues crystallized, I think everybody thought it was entirely appropriate for the ABA to file an amicus brief, but the issues kept changing so quickly, and the ABA's position sort of was information, that it was a little bit challenging to try to figure out exactly what issues the ABA should speak to and where it should end up. I mean, I think in the end it came out fine, and the ABA did, I think, a quite effective brief, but it was an interesting example about how, you know, it was an area, perhaps unlike Estelle's, it was an area in which there was no question that the ABA was going to be called upon to say something, but there was a little bit of sort of improvisation, I think, and sort of trying to figure out exactly what ABA's position should be.
No one started off small here, huh?
So this is Kristi. My first interaction or major interaction with the ABA actually occurred in my previous job. So prior to my coming to the ABA, I spent 7 years working on the staff of a U.S. senator, and one of the issues, legislative issues I was assigned to cover was immigration. And this was 1996. The Senate was engaged in a huge debate on the last major immigration reform bill that was passed, by the way, by Congress in 1996. And I got a request for a meeting from the ABA, from the person then in Government Affairs and the director of what would now be the Commission on Immigration, to come in and talk about some of the issues that were being considered as a part of that immigration reform bill. And I recall, you know, as you all know, you know, legislative staff meet with a lot of groups and a lot of individuals and hear a lot of opinions. And one of the things I do recall is, knowing I was going to be talking to the ABA, you know, having a sort of, even though I hadn't had sort of previous exposure with them, I had a sort of instinctual level of respect, knowing that it was the American Bar Association, an organization of lawyers, trusting that the information they would give me would come from a place of legal expertise, and, you know, that I could sort of discuss with them or have a dialogue on some issues, even some where my boss may not have been supported, but really rely on the information that I was getting from them. And so that was my first real exposure to the ABA.
Can I just echo something that Kristi said? She used the word information, and I think one of the things that we should be mindful of when we do resolutions, that I think we've probably soft-pedaled a little in this conversation, is the importance of the report. That in addition to being an advocacy piece for the resolution it is accompanying, it also can be a nice little law review type article without too many footnotes about the nature of the issue that is being advocated. And I think that the ABA as a trusted source of information for members of Congress and for members of the ABA is very important. So while the report doesn't technically have the effect of law, which the resolution does, it can be a really nice piece of source material going forward.
Absolutely, absolutely. And what I would say as we sort of move to closing out our webinar today is two things. And as you heard from our panelists, the first is definitely run while you can, because once you get roped into working with the ABA, you pretty much don't stop. It's incredibly rewarding. And after your first sort of voluntolding experience, as I've heard it called, where you're sort of volunteered but also not really given a choice in the matter, you sort of get addicted to this amazing feeling of working on these issues, because of my second point, which is that there's no small issues in the ABA. And there's few things you can do as a lawyer that can be as impactful or as important as your advocacy within the American Bar Association. It is a very large organization. As Kristi mentioned, it's an organization that represents lawyers and is made up of lawyers and forms this source of authority and this source of information, which just has incredibly profound effects. So that is the real reasoning behind the ABA policymaking process. I hope everyone enjoyed our webinar today. I don't know if any of our panelists have have final comments before we wrap up. Again, feel free to reach out to your section leadership to seek out any of the resources we mentioned today and to get working on policy.
Thank you, Matt.
Thank you.
Thank you.
Thank you. Great.